What we call today human rights were described as fundamental rights, constitutional rights, natural rights, but it was President Roosevelt who for the first time used the expression human rights to describe these four fundamental freedoms as human rights. So this is another aspect which should be kept in mind, and the simple reason is that human rights is an idea whose time has come. And when any concept whose time has come emerges, then no army, howsoever huge and large it may be, can repress it. So the concept of human rights, the language of human rights, the idea of human rights, the language, ideology of human rights, the vision of human rights, they all have come to live with us. There are two, three stories which explain the origin and genesis of human rights. The first story is that according to David Hume, of all the animals that have this planet Earth, nature is not so cruel to anyone as to men, simply because they have unlimited expectations, desires, and greed. So man is greedy. Man's needs and greeds are unlimited. Now in this situation, man could have solved this problem by living in solidarity with fellow men. But that could not take place because, as Hobbes has said, man is egoist, selfish, self-centered, brutish. So man does not believe another man. Man does not want to be under the control or restraint of another man. Man is therefore in a constant struggle for acquiring more and more freedom. This is the situation according to the Western philosophy. Man needs freedom, freedom and freedom, more freedom. And in this situation, what could have been the solution? Man was scared of man. Man was not only scared of man, man was also scared of the powerful state. So man wanted protection from oppression and exploitation of the state, by the state and powerful individuals. And it was then felt that man had, in addition to normal equipment like nose, eyes, mouth, and ears, something invisible, and that invisible is rights. And these rights were called natural rights. And that is why when you go through the history of human rights, you find that natural law theory, the idea of natural rights, played a very dominant role in the early evolution and development of human rights. The theories of natural rights, as propounded by Hobbes, Locke, and Rousseau, played a very important role in the universalization of the concept of natural rights. Even today, when we say that human rights are universal, the plausible basis for explaining it is that these rights have their basis in the idea of natural rights. Aristotle made a distinction between conventional justice and natural justice. So natural rights, according to Gross's, were the dictates of human region, and the movement was from the concept of natural justice to natural rights, and universality of human rights is generally traced to the concept of natural rights. We all have natural rights because we are human beings, and human rights derive from the concept of natural law, human nature. Although the present definition of human rights is quite different, because if you say that human rights are derivatives of natural rights, it means there is very little scope for the growth of human rights. Human rights have come to be recognized as natural attributes of human dignity. And we all are equal in the terms of worth and human dignity. And that is why it is said that human rights are universal. Even Indian Supreme Court has defined human rights as basic rights, as inherent rights, as immutable rights, as inalienable rights. In Ramdev Chauhan versus Bani Kant Das, 2010, 14 SCC 209 at 223, the Supreme Court said human rights are the basic, inherent, immutable, and inalienable rights to which a person is entitled simply by virtue of his being born a human. They are such rights which are to be made available as a matter of right. The constitution and legislations of a civilized country recognize them since they are quintessentially part of every human being. That is why every democratic country committed to the rule of law put into force mechanisms for their enforcement and protection. So, this is a workable definition of human rights, and we can start our discussion on human rights with this workable definition. But the most simple definition is that human rights are natural attributes of human dignity. Human rights are those rights which are held by us simply because we are part of humanity. Now, I want to make one point clear. There is a mistake which is sometimes done by many teachers while explaining the concept of human rights. They refer to the Magna Carta. Magna Carta was a constitutional document under which the king conferred certain powers not on individuals but on barons. It is said that by signing the Magna Carta, the King James put his signature on his death warrant. That's true. But human rights are not those rights which are conferred on individuals or a group of individuals under a particular constitutional document. Human rights are there, and these rights accrue to all of us simply because we are human beings. So human rights do not exist, do not depend on existence of any constitutional document. We are human beings, we are individuals, and because of being a human being, we are entitled to certain rights, and such rights are known as human rights. Although the distinction between fundamental rights and human rights has disappeared in recent years, and even our Supreme Court is using the concepts of fundamental rights and human rights interchangeably, but philosophically and historically, human rights are different from fundamental rights, from constitutional rights, from statutory rights, from customary rights, from elementary rights, from conventional rights. Human rights are held by all of us simply because we all are members of the humanity. So this is the point. So first story I just narrated lays emphasis on the need of man for protection from the powerful state and individuals. This is first story. Second story is that in the 17th century, the unwieldy huge Roman Empire was disintegrated, as a result of which a number of nation states emerged in Europe. Individuals were under the protection of local parish, local chieftains, local provincial government, and then the Roman Empire. What happened? With the disintegration of the Roman Empire, a number of nation states emerged in Europe. They were very powerful. They were asserting their sovereignty, and there was none to control their power, their authority. So man was very much scared. Business class was especially more scared. It is said that man at that time became naked. Naked in the sense he was without any protection of other entities. There were relationship between the state on the one hand and individuals on the other hand. So individuals needed some form of protection. The disintegration of Roman Empire created a kind of void in Europe. There was a need for a reordering of Europe because social, economic, and political conditions changed. Europe was in need of reordering. No, reordering of Europe could have done even around the concept of duties. But nation states were very much scared of the unlimited and absolute power of the Roman Empire held in the name of religion. So they did not want revival of the power of a religious entity. Duty is related to ethics and morality. So therefore, the concept of duty was not considered suitable for reordering of Europe in the 17th century. Remember, all ancient societies were duty-oriented societies. But trend has now changed. All democratic societies are today rights-oriented societies. The trend is from duties to rights. Although in jurisprudence it is said that rights and duties are complementary to each other. But so far as human rights discourse is concerned, human rights are not supposed to be contingent on the performance of duties by individuals. These rights are held by individual human beings simply because they are part of the humanity. So therefore, rights was considered as a suitable means, as a suitable concept for reordering of Europe. And that is why it is said that the modern conception of human rights had developed in the specific context of the social, economic, cultural and political conditions of Europe. They have developed in response to the specific European context. And this leads to the argument that human rights are the Western concept. And Western scholars and national governments take a pride in asserting that human rights concept is their own concept, and that concept has been accepted lock, stock and barrel by non-Western societies, by non-Western states in the course of time after the establishment of the United Nations, thanks to the human rights movement which is going on since then. We will consider this aspect later on, but for the time being, remember, first, genesis of human rights, natural rights. Number two, disintegration of Roman Empire, use of human rights as a suitable concept for reordering of Europe, and rights were recognized in the specific social, economic, political, cultural and moral conditions of Europe in the 17th century. But even then, human rights were essentially a domestic concept. States were free to deal with their individuals in the manner they liked. But things changed after the massacre of over 6.4 million Jews at the hands of the Nazi government in Germany. That not only triggered Second World War, that Holocaust outraged the conscience of mankind in Europe. Enough is enough. There should not be any Holocaust in future. And there was an almost near consensus that whenever any new organization would take place, the position of League of Nations promotion and protection of human rights and fundamental freedoms would be one among the fundamental tasks of the new organization. And you all know 26th October 1945, adoption of the United Nations Charter. Just go through Article 1 of the United Nations Charter, and then Article 1, Paragraph 3 speaks about promotion and protection of human rights and fundamental freedoms for all without any discrimination based on race, religion, nationality, etc. So United Nations was entrusted with the task of promotion and protection of human rights under the United Nations Charter. The rest is the history. So this is another important aspect so far as the evolution and development of human rights is concerned. And with this begins internationalization of human rights. I refer to the emergence of international human rights regime since 1945, and the basis for that, for the establishment of that regime was United Nations Charter. So there are three stories which a teacher can narrate before students while explaining the concept of human rights. Man needs protection from the state, from powerful individuals. First. Second, there was a need for a secular concept for reordering of Europe, and human rights were adopted as a suitable concept for that purpose. And third, internationalization of human rights in the wake of the Holocaust that had taken place in Germany at the hands of the Nazi regime, and establishment of United Nations Charter, establishment of United Nations. Now, I have tried to explain the concept of human rights in my own way, but students generally need some definitions of human rights so that they may explain it during their examination. And here I would like to begin with one important definition of human rights. Nickel is a well-known American scholar. He has identified 8 characteristics of human rights, but I will tell you 4 characteristics of human rights. Generally, when I ask students or teachers what are the differences between human rights and fundamental freedom, fundamental rights, they fail to explain it. But just remember, number 1, human rights are moral or legal claims. Moral or legal are both types of claims. For example, killing is forbidden in all regions. Right to life is recognized in many national legal systems. And right to life is also recognized as a precious and variable internationally recognized human right. Right to life is supreme human right, and therefore it enjoys the status of just cogence under international law, peremptory norms from which no derogation is permitted. So you find killing is prohibited in religions, all religions. Killing is also prohibited under various national constitutions and legislations. Killing is morally reprehensible and killing is also legally prohibited. So this is the claim. This is legal or moral or both types of legal as well as moral. Number one. Number two, these claims are of far-reaching significance. Not every claim may be considered as a human right. Far-reaching significance is required so as to involve state responsibility of the state responsible for violation of these rights. This is second. Third is, to the extent these legal or moral or legal as well as moral claims are recognized under the constitutions of the state, there are better prospects for their protection and implementation. And number four, human rights standards are not high standards. Human rights standards are minimal standards. It means if a state so desires, it can provide more protection than human rights standards laid down in various international convention declarations and covenants. Human rights do not take care of all kinds of stupidities. Human rights do not take care of all kinds of different things. Human rights are minimal standards, and these standards are supposed to be observed by all individuals, organizations, and nation states at the international, regional, and domestic level. This is one definition. So this is very important. I am repeating it again. Human rights are moral or legal or moral as well as legal claims. These claims are of fundamental importance and their violation involves state responsibility of violating states. To the extent these claims are recognized under a national constitution and legislation, there are better prospects for their protection, implementation, and enforcement. And number four, human rights standards are not high standards. In fact, they are minimal standards which are expected to be observed by states and other stakeholders. So this is one important definition which now I come to other definitions. Number one definition, another definition is given by Matthew Ritter. He says that Western human rights developed from the European Enlightenment are deeply rooted in the ancient Judeo-Christian heritage, which accords absolute, universal, and egalitarian value to all individuals. Intrinsic to the notion of human rights, according to this construct, is the idea that human beings have inherent equal dignity or equal worth. So, human rights, as I told you earlier, are those rights which are held by every individual simply by virtue of being human. To quote Seneca, at the source of public liberties, we find an ethical value and ethical vision which confers on human rights a status independent both of law in the traditional sense and of ideology, a value that cannot be considered from the standpoint of what is valued, what is comparable, relative or valuable, what is effective or practicable. This value or vision is the worth of the human individual. B.G. Ramcharan, a noted scholar of international law, points out that human rights are legal rights which possess one or more of the following characteristics: appertainance to the human person or group, universality, essentiality to human life, security, survival, dignity, liberty, equality, essentiality for international legal order, essentiality in the conscience of mankind, essentiality for the protection of vulnerable groups. So, this is a secular idea, as I told you earlier. Then Jan Worting observes that the concept of human rights is the product of both enlightenment and the rise of a new social order based on industrial production. Reader argues that rights talk would base itself not upon the extrinsically revealed truth of the divine, but upon the intrinsically known truth of the human. So, anthropocentric concept. You all know the distinction between ecocentric and anthropocentric. We have human rights, but these are not divine rights. We have rights because we are human beings, and as human beings, we are entitled to have certain rights, and these rights have come to be recognized as human rights. Now, the assertion of Western scholars is that human rights is the contribution of Judaic, Christian culture and civilization. Western scholars have been asserting this proposition for a long time. And I was so much irked by this kind of assertion that I try to find out whether non-Western societies, whether societies in Asia did not have their own notions of human rights. And then I wrote an article, The Indic Perspective of Human Rights and its Relevance, published in Indian Journal of International Law of the year 2003, where I have demolished their substance. Because when I was writing this paper, a very fierce and fighting debate was going on this aspect known as universality versus cultural relativism. Singapore, China, Malaysia, all these countries were fiercely asserting that you have your own concept of human rights and we also have our own concept of human rights. So culture, culture specificity should also be taken into account. The level of development and advancement of countries should also be taken into. And if you go through the history of rights, you will find that there may not have been a concept of human rights as is known today, but notions of human rights existed in one way or the other. For example, in India, egalitarianism, secularism, religious tolerance, the concept of human solidarity were recognized during the regime of the Emperor Ashoka. The only difference is that we had recognized human rights in terms of our duties, general duties, specific duties, absolute duties, voluntary duties, like that. So, human rights should not be considered the exclusive contribution of European states. Due to historic reasons, the modern concept of human rights has come from the West simply because almost all states became member states of the United Nations. So, this is another aspect which I can discuss it, but it is better if it is discussed in any other lecture. Now, we should also think of how to teach human rights. And I can tell you some of the ways and means how we can provide quality teaching with human rights to our students. First thing is that interdisciplinary perspective of human rights. Too much legalistic approach in teaching of human rights will not be fruitful. So Socratic method is good, lecture method is good, so that a teacher may provide a comprehensive viewpoint of human rights to students in the class. But another way, that is group discussions, moot court, seminars, poster competitions may also be useful in teaching human rights. I would go one step further. Don't teach human rights the way Western scholars do it in their own schools. We should try to contextualize the teaching of human rights. And for that purpose, we can refer to the contributions of Raja Ram Mohan Ray, Ishwar Chandra Vidyasagar, Narayan Guru, Mahatma Gandhi, Ambedkar, then Phule, their contributions as social reformers in our society. We can also refer to the contributions of Nelson Mandela, the first president of independent South Africa, who was immensely influenced by Mahatma Gandhi, the father of nation. Likewise, Martin Luther King Jr. So what I want to say is that the concept of human rights should be taught not just by referring to the provisions of the UN Charter. We can also start our teaching of human rights by referring to Indian social reformers who contributed to the freedom struggle, freedom movement, who contributed to the emancipation of women from evils, social evils. So this is one way. Then debates. Debate may also be used. Students will be very much interested to participate in debate on human rights. And then storytelling also. Instead of starting with the discussion of an abstract idea, it would be better if we start with a story and then we ask the students to give their reactions. Then we can shift to look, this story has this moral and these rights have been violated in this case. So there are various ways and means to teach human rights. Socrates' method is a predominant method, but other methods should also be used. Seminar, group discussion, poster competitions, debates, storytelling, all these may also be useful in teaching the concept of human rights. And I told from the very beginning, interdisciplinary perspective is necessary. Relations, just put it not just as a legal subject, but also as a subject linked with ethics, morality, politics, sociology, economics, and so on and so forth. In 2000, I presented a paper on human rights of aspects of poverty. At that time, development approach to poverty was recognized by the United Nations. United Nations recognized the importance of human rights approach to poverty only in 2002. So human rights, the teaching of human rights, the study of human rights, research in human rights provide us a vision to look a problem facing us, our society and the humanity at large, and addressing it in a very fruitful and effective manner. Thank you.